Ken Gerber here, and you're watching Law and Gerber. So I've been thinking to myself, because I don't really know what it's like to be anyone but myself and to think like an injury attorney, what do you think we're looking for when you call us? I'd imagine for some of you it's not a very pleasant phone call to make, or perhaps at the very least it's just out of your comfort zone and you're not quite sure what to expect. I can't speak for any other injury attorneys, but I know when you call Gerber Injury Law and you get me on the phone, I'm thinking of the easiest way that I can break it down for you so that you understand the most important categories that go into determining if we have a case. There are so many factors, but I've broken it down into three main categories. Number one, negligence. Number two, injury. And number three, insurance. Now, as I've discussed on a handful of prior videos, without negligence, even though there's an injury, there's no basis to hold someone else responsible and collect against their insurance. More specifically, in episode 6, we talked about this in detail. So please go back and check out that video when you have un momento, por favor, for a more detailed discussion. But to break it down simply, did someone act unreasonably? Or did they fail to act reasonably? For car accidents, were they driving too fast for conditions, which would be considered unreasonable? Or did they fail to stop at a stop sign, which means they failed to act reasonably? In the setting of a store or business, was there an unreasonably dangerous condition, like debris on the floor, that they failed to clean up? Without an injury, even if there is negligence, there's nothing to force the insurance company to pay for. This is the "I could have been hurt" or "I could have been killed" category. Although those statements may be true, legally speaking, we have to have actual injury to be able to get an award, which is why sometimes you'll even see people straight up faking injuries, which is something we will discuss the repercussions of in another video in the future. The insurance companies like to say it like this: we don't pay speculative damages, which just means if there's no real injury, there's no real value or case. The final category is insurance, and it's a big one. Tell you what, I'm going to let Megan explain this one to you, because I just love the way she explains things.
Hey everyone, long time no see. Well, we often talk about how much insurance is available, such as insurance limits. But why the focus on insurance? And can you forego the insurance and sue civilly or sue personally? Can you settle for the insurance and still sue personally? These are great questions, and once you hear the explanation, they are much easier to understand. When someone causes injury because of their negligence, they are personally responsible for the full value of whatever injury or damages they cause, period. Whether it's $100,000 or $1 million injury, they are responsible for that value. The real question's how do you get it? Most people don't have the kind of money laying around to be able to just pay another for those significant injuries. So what they've done is bought an insurance policy, car insurance, or homeowner's insurance that says if they negligently hurt someone, their insurance company will pay up to the amount of their policy limit to get the case settled for them. In return, for paying for the insurance, the individual gives the insurance company the right to evaluate, negotiate, and defend the case, and the insurance company has the obligation to make sure they protect their person called uninsured. So, here is how that plays out. Let's just say that you're in a car accident and get hurt. You get treated by your doctors to get better, and they document what your injuries are, and your attorney prepares your case to prove what the value of your injuries are. If the other driver has more insurance available than the value of your injury, you try to reach a negotiated settlement with the insurance company. If you do, you sign a release saying that they will pay X dollars, and in return, you agree to never sue their driver. That sounds simple, right? Well, it's not. but it is a straightforward concept. Okay, so let's change it up. Without getting into the specifics in this video, let's just skip ahead and say that the value of your injury is worth $100,000. But the person who caused the accident only has $50,000 in insurance available. Once your attorney proves to the insurance company that the value of your case exceeds their insurance policy limits, they still have to try and get you to sign a release saying not to sue their driver. But why would you do that? You don't have to settle for their policy limits. You can reject them, file a lawsuit against the other driver, go to trial and prove the value of your case is $100,000. Congratulations! That driver owes you $100,000. At the end of all those years in the court system and going through a trial, the same insurance company that offered you their $50,000 policy limits before will come again and say, here's our check for $50,000, our driver owes you the rest. Now, the question is whether you can even collect. Going back to what was said at the beginning, most people don't have the money to pay for the injuries that they cause. So you're left with a judgment against the other driver that you may never collect. Oh, and that $50,000 that the insurance company paid that you could have gotten anyway without a trial, the costs of the trial have come out of that, so it actually costs you money to go to trial. I know that is a lot of information, but the premise is pretty straightforward, and all of this is a reminder as to why you really should call us if you're ever in any of these positions, because it's not always simple or easy to sort out what to do. I'm going to send this back to Ken and let him wrap this up for you all. Thank you for listening, and I hope this has helped.
Wow, I'm lucky. I mean, I feel like I need to do an entire video dedicated to how lucky I am to have her as a partner in crime. Well, I guess not an actual crime. I gotta be careful about how I say that one. Look, we are all about getting our clients the value that they deserve for their injuries. At the same time, we're here to educate them to understand that if all they're going to get is a moral victory, it may not be worth it to them. Can you collect the insurance, then sue? No. The insurance company will not pay unless you agree to sign a release for their driver, which you give up that right. Can you personally sue or civilly sue without going through insurance? Understand this, that's all we do is sue personally and civilly. When we sue the other driver, we sue them personally. We cannot sue the insurance company. We can't even talk about insurance in court. In the meantime, the insurance company hires the lawyers to defend the other driver. It pays for all of the costs of the defense, and if you win, it pays for what you've won. The whole time without the jury even knowing that it's an insurance company that's involved. Let me tell you a quick story. I once knew a guy who served on a jury for a car accident case. And he was a very smart guy and had been around the block a time or 10. He was very proud to tell me that he was the foreman of the jury. He went on to tell me all about the case and how there was definitely negligence and there was a real injury, but they did not award any money. And I asked him why. And he told me that it was because the jury figured that the injured person had already gotten the insurance money and now he was just trying to get more money by suing personally the driver. He felt so badly when I explained to him that the insurance company was hiding behind the rules in court and that the poor injured driver was now not getting any money for his injuries. How sad is that? The bottom line is this, without insurance, even if there is a provable injury and provable negligence, there's likely no money available to recover. In conclusion, it's a safe rule. Just always call us if you're ever in any of these situations. Let us figure it out so you can focus on recovering and healing. You have enough to deal with.
Hey babe, guess what? Guy he's in a pickle of a situation. Stuck his hand in a jar of pickles, razor blade was in there. Sliced his finger. Very pickly, vinegary. It hurts.
Sounds pretty bad.
It is.
Until next time. Have I? Is it going? It's going. Now, all those...
In return for paying...
And I'm going to have Megan explain this one to you because I just love the way she explains things.
Once your attorney proves to the insurance company that the value of your case exceeds their insurance policy.
But to break it down simply, did someone...
But you don't have to. Why would you... Wait, hold on.
And I'm going to have Megan explain this one to you because I just love the way she explains things.